A mom is supposed to be a daughter's first best friend, someone you play dress up with, braid hair with, and giggle with. But in one Florida neighborhood, that bond was possibly shattered in the most unthinkable way. Police say 27-year-old Roshan Gatlin didn't just betray that sacred role, she allegedly tried to end her 3-year-old daughter's life. Investigators allege Gatlin stabbed the toddler more than 20 times. Now, instead of bedtime stories and lullabies, this child is recovering in a hospital bed, and her mother is sitting behind bars charged with her attempted murder. I'm Kennedi Walker, and I'll walk you through the details. On TikTok, Roshan Gatlin and her daughter appeared inseparable. In this video circulating online, the two are seen dancing, singing, and playing together. Law&Crime blurred the little girl's face for privacy. The child is just 3 years old. But weeks after those videos were posted, the mother behind them was arrested. According to the Palm Beach County Sheriff's Office, the alleged attack happened on April 21st, 2025. In court documents obtained by WPBF News, deputies were called to the family's home that afternoon. The person who called 911, the little girl's father. He allegedly told the officer that Roshan Gatlin had stabbed their daughter repeatedly, and he didn't just say it, he reportedly showed them. According to police reports, the father provided home surveillance footage that appeared to capture the moments leading up to the incident. In one video, investigators say a woman, identified by law enforcement as Gatlin, walked into the kitchen and exits holding what appears to be a knife. In another clip, police say she's seen taking her daughter by the hand, leading her towards a hallway. That little girl was reportedly stabbed more than 20 times. The wounds were on her torso and right arm. First responders rushed the child to a nearby hospital. She is expected to survive with no life-threatening injuries. But the trauma remains. A body that should be covered in glitter and princess dresses is now permanently marked by something else. Scars, physical and emotional, that will tell a story she's far too young to understand. Investigators have not said what led up to the alleged attack or where the child's father was at the time the stabbing reportedly happened. Roshan Gatlin was arrested and charged with attempted first-degree murder. She appeared in court the next day. According to WPEC News, that's when a judge moved forward with a Baker Act court order. That law, also called the Florida Mental Health Act, allows someone to be taken into custody and held up for 72 hours if they're believed to have a mental illness and pose a serious threat to themselves or others. According to WPEC, that judge said, quote, "When someone stabs their child 20 times and there's voices in their head, it cries out Baker Act." It's unclear how long Gatlin may have been experiencing these alleged symptoms or whether she has a formal diagnosis. The judge ordered Gatlin is not allowed to have any contact with minor children or with any witnesses involved in the case. As for her daughter, she's recovering and is expected to be released from the hospital when she's healed. And joining me to talk more about this case is legal expert Melba Pearson. Melba, thank you so much for coming on. What a sad and tragic story. Let's just jump right in. In this case, the judge is seeking to utilize the Baker Act, which is a Florida law to initiate an involuntary psychiatric examination of a suspect. Walk us through the process. How would it go? Is it often used in violent crime cases?
Yeah, so again, I agree with you, Kennedy. This is just a very tragic and sad situation, and it very much does scream of a mental health concern in this particular instance. So what the judge is going to do is, first of all, make sure that the defendant in this case is evaluated, and they're going to receive a proper medical evaluation by a team of psychiatrists. Usually that means transporting her to the nearest facility. That could be a regular hospital, or it could be one attached to the jail. It all depends on the location and sort of, bandwidth and what's available, and also speed, because when you're looking at a Baker Act, you basically have 72 hours to be able to figure out if somebody does have a mental health concern, and if so, what the appropriate diagnosis and treatment should be. It's not an indefinite type of situation. So if the defendant is being held in custody, she will be transported from the jail to the hospital, held until the evaluation and everything is complete. Then she will be brought back to the jail. If she's out of custody, which I would not anticipate in this sort of crime, but if she's out of custody, then she would be taken into custody for those 3 days and then released back on whatever prior conditions of release she had. So if it was, a house arrest, then she would go back home to house arrest. If it was, no conditions specifically, then she would go back to reporting to her officer, etc., as part of the pretrial process.
I want to thank Morgan & Morgan for sponsoring today's Law and Crime YouTube takeover. If you've seen our videos, you know Morgan & Morgan is a proud sponsor of Law and Crime, and that our content proves the world isn't always safe. When you're hurt, it can be confusing, it can be scary, and you don't really know where to turn. Well, Morgan & Morgan, America's largest injury law firm, can help. They're the largest injury firm because they win a lot. Morgan & Morgan recently received verdicts of $12.2 million in Florida, $26.2 million in Philadelphia, and $6.8 million in New York. All of these, by the way, were significantly higher than the highest insurance offer. Also, there's a $0 upfront fee, so you only pay them if you win. If you've ever been injured in an accident, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less without having to leave your couch. To start your claim, visit www.forthepeople.com/YouTube takeover. Could the Baker Act evaluation impact the criminal case at all, though?
Yes and no. So yes, and that's always like the kind of soft legal answer, but everything always depends on the facts, right? So yes, it can impact the case from the perspective of if it's clear that she was having a mental break and that she did not understand the severity of her actions, then there could be a situation where she may be in treatment for X amount of time, and then the charges are dropped against her once she's been restored to competency. And it could also impact the case from the perspective of, yes, there's some borderline mental health issues happening, but does it rise to the level of her not understanding the severity of her actions? And so in that instance, the case will still proceed as normal, with the defense really lodging a mental health defense as part of the broader case. Again, this is a situation that I don't see being resolved via trial, because again, with the mental health aspect being so prominent in this, and the actions that were taken were so shocking and seem to be out of character in a lot of ways, I think that this is something that's going to be resolved with a plea that's going to include a vast array of mental health components, including having to get treatment, complying with medication, maybe it might be an inpatient situation, all of those types of things.
Right. And so potentially, if she is found mentally ill, we're thinking maybe not jail time would be the best case for this scenario.
Correct. So, and let me just put a finer point on this. So there's a situation where if someone is, first of all, found to be incompetent, that's not what we're talking about yet here. If she is found to be incompetent because she does not understand the charges against her, she doesn't understand the severity of what she's done, she can't participate in her defense because, she's just not present, then she would be committed to a mental health facility for X amount of time. It could be 3 years, could be 4 years, could be definitely a term of years. And the case would keep coming back in front of the judge periodically to be like, has she been restored to competency? Now, let's say she's taken her medication for a year. Has that now brought her to the point that she understands what's happening around her? If the answer is yes, then the case may come back to court, and then we'll go the normal criminal track. If the answer is no, and it keeps being no for years and years on end, then eventually the case gets dismissed altogether, because you can't keep that case open in perpetuity if it doesn't seem like the person is ever going to be restored to competency. That's different than having mental health issues and being competent. So you can still have schizophrenia, bipolar disorder, but the same way, like we may know a neighbor or somebody with those diseases, they're able to go to work, they're able to function. That's a separate track. And in that instance, if it's found that she is competent to proceed, then it's a matter of, is this case going to be pled out with mental health conditions, or is this a situation where is going to go all the way to trial, again, which I don't think is going to happen. But it's two very separate tracks: lack of competency, or you're competent but you have mental health issues. How can we address this in the criminal justice system?
Is that when the suspect, like hypothetically, would plead not guilty by reason of insanity in this case?
Somewhat. So again, it depends. So in terms of not guilty by reason of insanity, that's usually something that comes about when it's clear that the person has competency issues, right? So that's one aspect. Now, when she goes to court, the defense can say, listen, she pleads not guilty, but you're not going to necessarily say by reason of insanity. You're going to really go about it in terms of again, she's suffering from bipolar disorder or something along those lines, you're not clinically insane per se, but you have mental health concerns. So again, attorneys are very careful in terms of saying not guilty by reason of insanity, except for when you see a situation like the Aurora movie shooting, right? That person was clearly, not in their right mind. So that may be a situation where you see not guilty by reason of insanity, but those are very much used sparingly.
Well, I guess that brings me to my next point. How exactly do courts balance mental illness with criminal responsibility?
Yeah, and it's a tough balance. The key always has to be, what do the doctors say? And you can also have a situation where you have a battle of the experts. So let's say you have the court appointed psychologist or a psychiatrist examine the person, and they're like, okay, I think they're competent. But then you may have a defense expert that examines the same person and says, I don't think they're competent at all. And so now you have to have a hearing, and the judge is going to have to hear all the different expert evaluations, read the paperwork that they generate as a result, and then make a decision as to which way the case should go.
How serious is this charge, and what kind of sentence could it carry if convicted?
So this is an attempted murder charge, and basically it's a first degree felony. So she could be looking at about 30 years, potentially life, because of the fact that this is a child involved. So that's a very much an aggravating factor. But again, a mitigating factor would be the mental health aspect. So again, this is not a case that I see that is going to go to trial. If I had to guess what a plea would look like, again, depending on what the family has to say, all of that, and also what the Department of Children and Families has to say in terms of whether or not the child is going to remain in that home, or is going to be put into care, or is going to be taken care of by another relative, something along those lines. I could see a scenario of extended probation for maybe, 5 years, 10 years or so, with the condition that she continues to get mental health treatment. Maybe she may have to reside in a facility, something along those lines, until that issue is pretty much resolved. And then maybe she can reapproach the court after, maybe at the halfway point, and say, listen, I've been complying, I'm doing great on my medication, I've been able to hold a job, of not hearing voices anymore, etc. And then maybe the court may modify the sentence at that point. But that's kind of how I anticipate that this would go, despite the max being 30 years to life or so.
And police allege that the child's father showed them surveillance video, not of the crime itself, but of the suspect, allegedly walking into the kitchen, grabbing a knife, and allegedly bringing the toddler into the hallway. How would this typically hold up in court?
Well, I mean, this would be very critical evidence because again, it's showing the incident, or all the factors that are happening right before the incident occurred. So this is very important context for the jury as well as the judge to know and understand, in order to make a determination whether or not she was in her right mind, or whether or not she was the person that did the crime, which again, that doesn't seem to be the issue. The question is the motivation. Why? Was this due to mental health, or was this due to, some very ill or evil intent?
Speaking of that, I was just about to ask, what role does intent play in a case like this?
Well, I mean, again, you're looking at attempted murder. So the question is this attempted second degree murder? Was this a heat of passion type situation? Was it attempted first degree murder, as in she was speaking about, killing her child for weeks beforehand? All of those things are going to play a role in terms of, what's the best and the most appropriate course of action.
Just a reminder, that child is 3 years old, according to police. What happens to the child during and after a case like this?
That's always the really difficult part. So clearly, her father's in the picture. So if her father is able to care for her on his own, then that is probably the most preferred outcome. But if the father is somehow unable to take care of the child for whatever reason, whether it's work schedule or something, maybe there's criminal history or some other concerns that we may not be aware of at this time, if a grandparent or a relative of some sort would be able to come forward and take care of the child, that would be next preferable. And then the worst case scenario is that the child gets taken into the foster care system, which we all know is often a mixed bag and doesn't always serve the child well in the long term.
Right. And I know you mentioned that there's potentially a chance that this could be, pleaded down or some type of deal happens. If that doesn't happen, let's say hypothetically they end up going to trial, will the child need to testify in court even at such a young age?
As a former prosecutor, I would never put the child on the stand. That there's just no way. Because again,
Hmm.
what exactly can a 3-year-old tell you without being overly traumatized? Now,
Hmm.
in order to question a child of that age, usually you bring in social workers, you have them, basically coloring and try to elicit information in a very non-confrontational manner and just sort of letting them give information often over a course, over a series of meetings. It's usually not just one discussion as you would with an adult victim and one and done. This is something that has to be done very carefully and methodically. And so to put that child on the stand would be, again, very destructive and would not necessarily elicit the best information. You'd be seeking to possibly bring in the social workers and others who met with the child, even though normally that's an out of court statement. There would be exceptions that would apply because of the age of the child and because of the very delicate nature of what happened.
Can a parent ever regain custody after being charged with attempted murder? I'm assuming not.
That is going to be a very difficult road ahead if she were to try and do that. Again, it's all going to depend on what happens in this case and if she can assure the courts involved, the family court, that she is fully rehabilitated, is going to comply with her medication. But again, that would be a long arc in terms of she would have to have, first of all, supervised visits, and that would continue for a period of time, and then maybe unsupervised visits, and that would continue for a period of time. And then at some point, way in the future, she may be able to regain custody. But again, I don't see that as very, very likely in this instance.
And we touched on this a little bit in the beginning, just basically the courts determining the best long term placement for the child. How do they go about that? What steps does Child Protective Services take in these situations?
Well, they're going to, first of all, look at whether or not there is a viable caretaker anywhere in the family. Do they have the means to be able to take care of the child? Do they have a stable home? Is it, they would be doing home inspections to see, is the home clean? Is there food in the fridge? Is it safe for the child to be able to be there? Are there any, for instance, like large dogs in the home, or things like that? Are there children in the home? How many other children? So all of those factors would have to be looked at. And at the end of the day, their mandate is to do what's in the best interest of the child. And, every child is entitled to a family. Now, you'd like them to have the best family or the best situation. That's not always the case. And so that's why sometimes children don't end up with a family member, they end up in care, which again, is not always necessarily a great situation. So they often find themselves between a rock and the hard place in terms of the options that they have available, but they're going to do the best that they can to evaluate what's going to be the safest situation for this child to reside in moving forward.
How long could this process take? Whether that be a trial, whether that be a plea, what are we looking at? Is this another situation where we probably won't know the outcome for a year or so, or would it be sooner?
Absolutely. We're looking at years here. This is not something that's going to be easily resolved because, again, when we're dealing with the human mind, we're dealing with mental illness. It's not like, oh, I have a cold and it's going to be gone, over in a week, right? This is something that you have to have consistent treatment. It takes a while for the medication to build up in your system and then have an effect. Then the medication may not be correct. They may have to adjust it. And then that starts a whole nother series again. So we're looking at the very least probably a year to 2 years before the court can really address what would be the best outcome here. It may be longer, it may be less, again, depending on how she responds to medication, but this is not going to be an issue that will be quickly resolved.
And in the meantime, does the suspect sit in a jail cell or does she potentially sit in a mental health facility?
She may end up staying in a mental health facility for several months. That's a possibility. It is also possible that she'll remain in jail and get treatment in the jail system. So, again, there's psychiatrists and psychologists that work in the jail so they can make sure that she's taking her medication. She can be taken for therapy or for group sessions, whatever is needed. So, both of those options are available generally.
And speaking of therapy, is there a chance that the court could mandate, therapy for the child? I mean, I know she's only 3 years old, but this is, a very tough situation, being allegedly stabbed, dozens of times.
Yes, well, unfortunately, the judge does not have jurisdiction over what the victim should or should not do. So this would be an issue for family court. Normally, in issues that involve a child, especially a child of that age, a court-appointed guardian would be basically come into place in terms of being able to again speak for the best interests of the child, speak for the child in court, things like that. Because again, you have a father that may not always give the full story because there's a lot of dynamics happening there. You have the defendant who clearly can't speak for her child, so the guardian would be the one to make sure that the child is getting therapy and also helping be that liaison between the criminal court and the family court. And now the family court is where that sort of therapy and treatment and sort of mandates around what happens within the family, that would come from there. But the criminal judge cannot speak to what happens to the victim outside of that.
Well, this is a story that we will definitely be following. Melba, thank you so much for coming on today.
My pleasure.
Gatlin remains behind bars and was not given a bond. For Law and Crime, I'm Kennedi Walker.